Hello, my name's Ken Bell, and as I expect you know, I'm the receiver in the Rex Venture and Zeek Rewards matter. I really appreciate the time all of you participating in this tonight. You know, if it were up to me, I'd like to do this frequently. I know how many questions you have and how much angst this has caused you. So I wish I could talk to you more often, but we're going to take this opportunity to do that tonight. You know, if we could have a town hall with 900,000 people, I'd like doing that too. But that doesn't seem very practical with people from 100 countries being involved in this thing. So I tried to make the best of it tonight. We had about 1,500 emails from you folks after we announced that we were going to do this, and we're going to take emails during this call as well. But we boiled down the 1,500 about 20 or 25 categories. I'm going to try to address them as we go through. But we do welcome your questions as we go along, because you know, I might not hit everything you want to talk about, or I might not go into enough detail. And this call is for you. I mean, I'm sure we have a lot of people on the call of various interests, whether it's attorneys representing people who are kind of resisting my efforts, or whether it's the press. But really, I want to talk to you, the affiliates. And so when you have questions, send them in. Some of you have already figured out how to do that. But apparently the way to do it is at the top of your screen, there's a pull-down menu, and you click on the Q&A screen. And do not hit the chat button, they say. Address your questions to all panelists, and somebody here in the room will be looking at them as we go along and try to make sure that I answer the ones that come through that I haven't touched upon already. If you want to see this presentation full screen, I'm not sure why you want to do that, but if you want to, you'll see a window that has an icon of three people. Click that, and that will open up a window that takes up about a third of your screen. And if you click on the arrows that point out, that will make the presentation full screen. We tested this system this afternoon, and we hope everybody can hear me. Most computers that we tested it with, their speakers were adequate to hear me. I'm not usually particularly soft-spoken. But if you do have any trouble with me, we're recording this. We're going to post it on the website as we can turn it around. And so that those who couldn't participate today, or if you really do want to hear it again, you can log on and listen to it any time. You all know how we got here, that on August 17th, the Securities and Exchange Commission brought a complaint against Paul Burks and Zeek Rewards, Rex Ventures, alleging that there was a Ponzi scheme and a pyramid associated with all of this. And I know that a lot of you have raised questions about whether that really was a Ponzi or a pyramid scheme. All I can say about that is that the SEC alleged it, and Paul Burks, who was Rex Ventures Group, consented and agreed to the court order, where the court took exclusive jurisdiction of the assets of the company. And so when a lot of you reference that, you know, I somehow closed down Zeek Rewards, rest assured I didn't have anything to do with it. The SEC and Paul Burks entered into an agreement. The court took custody of the company and its assets, and then after that appointed me as the receiver. It's actually kind of interesting. I found out that I'd been appointed receiver about 4:45 on that Friday afternoon, and I got an email saying, "You've been appointed receiver." Thousands of you found out about it before I did, actually. You'd read the complaint, you had read the order, you'd gone on my web bio, and several thousand of you sent me emails and called me within the first several hours. So you knew more about it than I did. And it was really kind of overwhelming at first. I read the first several hundred emails to get a sense of what was going on and who you people are and how this has hurt you and how rightfully upset you are about all this. So I've always seen my job as working for you. Now, I answer to the court. The court appointed me, and obviously I answer to the SEC as well. But mostly I think of myself as working for you or answering to you. And I consider it my job to, as cost-effectively as possible, recover all the funds that can be recovered and to get them as fairly and as equally and as quickly as possible back out to you folks that have lost money in this thing. That's my only job here. And I appreciate the support of those who have given it, and I understand the frustration and some of the criticism of those who aren't so excited about what I've done and how I've done it. But I want to go through this 20 or 25 categories of questions that you've presented to us and try to hit on each of them with as much time as we have. You know, one of the first questions is, was this a Ponzi scheme? Was this a pyramid? I was a federal prosecutor for 18 years. I've been in private practice for another 11. I know a Ponzi scheme when I see one, and this was one. Now, people have asked, who's proven that, or who's going to prove it? It's been essentially agreed to by Paul Burks by consenting to the order, shutting it down. And there will come a time, as we try to get money back from folks that we think we are entitled to give out to you victims, there will come a time when I'll have to prove it. We'll have to walk into a courtroom and prove to a judge and a jury that this was a Ponzi scheme, and we'll do that. The other question is, will Zeek Rewards ever reopen? Kind of oddly, I am Zeek Rewards now. When the court appointed me the receiver, I'd stand in the shoes of Rex Venture Group, Zeek Rewards, and it's not going to reopen. So when you see emails out there or blogs telling you that Zeek Rewards is about to reopen, it just isn't so. I've seen those from the early days, people representing that they've talked to various people, that this is a big misunderstanding that's about to be worked out, and Zeek will be open again soon. That's not going to happen. I've had a lot of questions from you folks asking if how I can communicate with you better, and I'm wide open to suggestions. As I mentioned before, there are nearly 1 million of you that were involved with Zeek Rewards to the point where you put money in and some of them took money out. Now, there's another 1 million or so who were involved in Zeek one way or another, but of the people who have money invested in this, there are about 1 million of you. And, you know, I wish I could take your emails directly. I wish I could answer them. I wish I could ask members of my team to do that or talk to you on the phone. But it really is impossible to do that, and I hope you understand the scope of it. We notified people of this conference call by sending an email to everyone who had sent an email to the receivership website. And I do caution you that's the primary way we can communicate with you. If you'll stay up on that website from time to time, we'll post updates and other things as we go along. But that's how we knew to email the folks who got an email. If you didn't get an email, it's just because we didn't know how to get up with you, at least through the website. So we will try to keep that as our means of communication. But if you've got suggestions, even like things like doing this call, I mean, we're wide open to assistance from you about how to do it. The next question that gets asked very often is how much money was lost and how much has been recovered. And of course, unfortunately, this is about money. The best we can estimate, and we're still getting our arms around the financial information here, is somewhere between $500 and $600 million has been lost by you, the affiliates. Now, we have seized and gotten control over more than $300 million so far. So we're roughly halfway home. But that's a huge gap. And as we'll discuss as we go along, we're going to do everything we can to seize and return more money to the receivership estate so that we can better compensate you people who have lost money. And that's going to take a while, as we'll describe. I'm going to try to go into as much detail about that as I can. But that's where we stand. We've got about 840,000 people who lost money in this. And we've got about 77,000 who made money off of this. Now, when I say people, as you probably know, it's a little bit imprecise because there are 840,000 user IDs that lost money and 77,000 user names that made more money than they put in. That doesn't necessarily mean human beings. A lot of people have more than one username. And again, we're trying to get our arms around that and understand how that's going to work going forward in the claims process and trying to make people as whole as possible. But that's what the straight-up numbers are. The next question I want to get into, because I know it's a huge point of irritation for you folks, or a lot of you folks, what's the cashier's checks. And I want to describe for you what we did and how we did that and why. When we took possession account and the cashier's check is written, that's not your money anymore. It's the money that's on the payee line of the check. And I, under the law, couldn't do anything but cash those checks, even if I had wanted to. I have to follow the law. I have to follow the orders of the court. And under the law, those were receivership assets. And I had no discretion about cashing those checks. And I know that doesn't sit well with some of you folks, and I'm sorry about that. There's a practical aspect to that, too. If you can imagine, we had tens of thousands of those cashier's checks. And we had no idea who they were, who they belonged to. Were those from net winners? Were those from people upline who were sending in money on behalf of others? Whose money was it really? So it wasn't a simple matter, even if I had wanted to, of just returning it to people who were out of money and were going to be entitled to get money back at the end of this. I just couldn't do it either on a practical basis or on a legal basis. I don't know if that satisfies you. I don't know how else to explain it, but we did what we thought was right, what the law required us to do, and frankly what we had to do. The next most asked question is how the claims process is going to work. And we're 4 months into this thing today, and I know a lot of you folks think we should have had this by now. And in our defense, all I can tell you is that getting our arms around the financial situation of this company has been incredibly difficult. The records of the company were spread out all over the office in over 100 boxes of hard paper. We've gotten, I think it's on the order of 10 terabytes of electronic data. And there are something along the order of 900 million transactions and all that data that we're trying to understand and trying to figure out how this thing worked, how money came in, how it went out, to whom and from how much. And so that's taking some time. And I'll tell you that the electronic data that Zeek and RexVenture had is a mess. It doesn't reflect accurate numbers. It's not complete. It's hard to find what's going on in there, and maybe some of you experience that. I've read a lot of emails about people who were dissatisfied with the electronic databases while this thing was up and running, and we're running into the same problems. But we will have, by the end of January, a proposed claim form for approval to the court. And we'll put in there the items that we think constitute real losses, losses that ought to be compensated. And we'll propose in there what kind of proof we think would be adequate to establish that. And we will have that available after the court lets people weigh in on it. I guess I should mention that. We'll propose a claim form, a claim process to the court. But there will be a time for people to weigh in and object to it and to tell us we missed something or that we shouldn't consider something that we are going to consider. But when that process is run, the court will approve a claims process, and we'll post it on the website, and we'll try to get email correspondence out to everyone we know of to let them know that it's up there. Now, again, I hope you'll check the website frequently, and I hope you'll see it when it does go up, but we'll put it up there and try to get the word out as quickly as we can. And we'll try to leave it open, whatever the court directs, but my guess is it would be along the lines of a couple $500 million or $600 million that have actually been lost. We're going to need to try to go find more money, or as much other money as we can. And we're going to do that by what you've heard called clawback litigation. We've sent out 1,200 subpoenas so far to roughly the top 1,200 net winners in this, asking for various records and asking for the money back, essentially. You might be surprised, but maybe not, that scores of those people have responded to us offering to cooperate, send us what we're asking for, and even pay back the money. So we're working with those folks to make that happen. Now, you also won't be surprised that a whole lot of people are fighting us on that. And, at the end of the day, we may not be able to come to an agreement with those folks about why they ought to pay us back and how much they should pay us back, but we're not going to let it rest there. In my view, people who took more money out of Zeek rewards than they put in should send the money back so that those who put in more than they took out can be made as whole as possible. Now, I can't tell you, and I won't tell you, because we can't do it. We're not going to get enough money to make everybody 100% whole. I get asked questions in preparation for this conference or every other day of the week. What's the percentage? How much of my money will I be able to get back? I don't know the answer to that. We're already pretty close to 50 cents on the dollar, and we're going to go out and get as much more money as we can to try to up that percentage. We're going to have to be smart about that. I mean, we don't want to spend more money collecting money than we actually collect, because that's just taking money out of your pocket. I know a lot of folks are worried about whether I am adequately protecting your money, whether I'm spending too much of it. The people who work with me are probably tired of me saying every dollar that we spend is a dollar that can't go back to you folks. And so I emphasize every day with everybody that's working on this, you be efficient, you be smart, and never spend more money trying to collect money than you're going to collect. So we're going to have to make those calculations as we go along. I also get asked the question of, will we be able to do clawbacks from people who are not in the U.S.? That's a difficult question to answer. It's another one that we're wrestling with. There are some countries where we have a better chance of getting money back from these net winners than in other countries. I'll just be straight up with you. There are over 100 countries where affiliates live through the course of this thing. And not all 100 countries have a legal system where it's very easy for us to go in there and claw back winnings from these net winners. But we're looking at where we've got the best chance and where we can, in a cost-effective way, go get money back from people who, in my judgment, ought to give it back. Another question associated with that is, well, how about the non-U.S. citizens, the non-U.S. residents who lost money? Will they be considered victims just like U.S. people? And I've read emails, and you can sort of see the justice in them, but I've read emails where people suggest, well, if you can't claw back from their countrymen, you shouldn't give money back to them. I don't think we're going to be able to do it that way. I mean, what's fair and right and just isn't dependent upon whether we can collect money from a net winner in one country, and if we can't get it, we're not going to pay victims in that country. I just don't think we can operate that way. We also get asked whether there's going to be some sort of priority about whether people who came in the last will get paid first, whether there will be a different proportion of compensation depending on how big your loss is. We are looking at those things, but I don't think it's going to work out that way. At least I don't think that's the way I'm going to recommend it to the court. My guess is you're all in this together, and to that extent I'm in there with you. And money lost is money lost. I don't think it matters when you came in. I don't think it matters how much you lost. It's been suggested to me in one email that I think I got even today that somebody lost $10,000 should get a bigger percentage than somebody lost $100 because $10,000 means more. I know that's true on a very human level, but I got to tell you, I've read some really pitiful emails from people who were out $100, $200, and that money meant a lot to those folks. It may have meant as much to them as people who were out $10,000. I don't know. I can't judge all these hundreds of thousands of comparative injuries, but there's some sad stories out there. I've had emails asking for as little as $49 back with a very hard luck story attached to it. So I don't see how we can justly make some sort of distinction between late people in, early people in, and different percentage based upon how much allow you to establish that claim and to make sure that the upline sponsor isn't claiming to have put money in for themselves that they really put in for you. So one of the things that's very helpful to us, frankly, is when you send in your emails, whether it's in response to this call or just on an everyday basis, telling us how this worked in your case, because we want to make sure that we know how this affected you and how your money went in and how your money came out, so that we know what to put in the claim form and we know how to evaluate the claims and make sure we're being fair and just with them. So do send those emails. You know, since we put the website up in mid-August, we have had tens of thousands of emails sent into the website. And in fact, we had 1,500 emails for tonight, I think I mentioned. Somebody reads every one of those. I read a lot of them. Now, I don't want to take the time and expense to read all of them. That wouldn't be very productive. But somebody reads all of them. And I get a summary of them every day. And when someone throws a new wrinkle into something or tells us something we didn't know before, that gets taken into consideration into our work plan and into our calculation. So please, use that website. It's how I get your emails. If you send emails to me at work, frankly, they get lost. I just can't personally read 1,000 emails. But if you send them to the website, they will be read, and I will get a report of what you're saying. And I'll be able to react to that. So please, I say again, use that website. That's how we can talk to one another. I've said on this in preparation for it and taking the emails that are coming in tonight, I said I don't want to dodge the hard questions. And one of the recurring hard questions that comes in is, am I just dragging this out to increase the fees for me and my firm? And is it true that we've already asked the court to begin reimbursed for $800,000? And yes, that's true. We've asked the court to begin reimbursed for in the neighborhood of $800,000. Am I dragging this thing out? Am I trying to generate fees? No. I know you don't know me. I don't know if you can come to trust me over a website either, but I take very seriously the fact that I have a fiduciary duty, that I'm under orders from the court to act in certain ways. And just as a person, I understand that every dollar we spend on this effort for you is a dollar that doesn't go to you. And so I'm asking you to trust me and believe me that we are going to do this as efficiently and as cost effectively as possible. It is my goal, it has always been my goal, for this to be the most cost effective receivership in history. I don't know what that standard is as a percentage of recovery. Whatever it is, I want to beat it. And so, yeah, we're spending money. This call, we're spending money. Folks have asked, some of the emails said, why are you doing this? This costs money. Well, we have to make those balances all the time. It does cost money, but I think this is important. And everything we do, unfortunately, costs money. But everything we do, I think, is important. And will be answerable to you ultimately. We'll have to answer to the court. Everything we spend, the court looks at and has to judge whether it's an expense that should have been made and whether it was reasonable. So I've got folks looking over my shoulders, even if you don't trust me. But I wish you would. Another recurring question that has come up very recent, obviously, is the e-wallets. Now, I know that there's a lot of concern about the e-wallets. And let me back up just a little bit to talk about how we recovered this $300 million and then where we are now. Pretty quickly after I was appointed receiver, we were able to locate about $225 million in various financial institutions around the world. There's still some overseas that we know of we haven't been able to get our hands on yet, but we're still working on that. But we sent out to all of the financial institutions in the country, frankly, not just the ones that we knew of, but all of them, with a copy of the court order, and informing them that this order was in place and that they should review it and act on it and freeze and send to the receivership any funds that fell within that order. And we got from the e-wallets, just like we did for many, many banks, what was represented to us to be the funds of Rex Venture Group and or Paul Burks. And like I said, that led to a couple of $100 million or more. And then we also had a whole lot of money that we were able to get either through cashier's checks or from other assets that we got our hands on. turned over so that they can be used to compensate the victims in this thing. Now, I did also tell them, and this applies to a lot of you because I've gotten a lot of questions, if somebody loaded their e-wallet with the intention to send money to Rex Venture Group or to Zeek Rewards, but never did, I don't see how that could be a receivership asset. Now, again, they're going to make their own judgment, but in my view, that's not a receivership asset. But if there are transactions within the e-wallets that, in their judgment, constitute receivership assets, then I think they're right in freezing them. Again, I don't know all the details. There have been some motions filed. Probably the e-wallets are going to have to respond and explain what it is they're doing and why. And we'll take a firmer position once we understand what they're doing and why. But I keep coming back to it. My job is to recover all receivership assets. And if there's some in those e-wallets, I want it. And I want it only so I can give it back to you. So that's going to play out in the next few weeks. Like I said, there's been a motion filed, and we'll have to do a response once the e-wallets give us a little bit more information so that, frankly, we know what position to take. But that's the situation with the e-wallets. Excuse me, somebody's giving me a question. It must be important. A few questions have come in regarding the exact name of the website. Okay? It's www. I guess you don't have to do that anymore. Zeek Rewards Receivership, all one word, .com. Okay? So I hope everyone will use that. I want to circle back to the cashier's checks ability. I said I wouldn't be able, because of time, to address everybody's individual situation, but there have been enough questions of the same kind that I want to answer, questions that don't necessarily apply to everyone. There are folks that say that they had a cashier's check that they sent and it's never been cashed by me or anyone else. It's still just out there. And you folks want to be able to approach your bank and get that money refunded to your account. I can tell you the status of the cashier's checks. With the exception of only a handful, every cashier's check that we have has been presented for payment. There won't be any more. Now, like I said, there are a handful that banks have told us they failed to pay the first time as they should have, and they've asked us to resubmit them, but that really is very few. So if you have a cashier's check out there that has not been presented for payment, or if you have one in your possession, because I've gotten emails telling me that too, they got returned in the mail or whatever, we're not going to be presenting any more cashier's checks, and you should just work with your bank to work that out. That's really beyond my control, but I want to convey to you, we're done presenting cashier's checks. So if you've got one that hasn't been presented, get to your bank and try to work with them and get that out. Money orders. Same sort of thing. There's a distinction in the law between personal money orders and bank-issued money orders. And we've put information up on our website rather than me try to take another 5 minutes explaining it to you. I wish that you would read those FAQs up there because we address the difference in some of these financial instruments about what can be stop payment, what can't be, which ones maybe you can approach your institution to get money back if it's been over a certain amount of time. I refer you to that. Please look at that because I'm not your lawyer, so I can't give you legal advice, but we've tried to put up there a summary of the law and hope that it applies to you in a way that you can use. We also had a lot of questions about whether people should file their own actions, fraud claims or join a class action or something else. Again, I can't give you personal legal advice. You need to decide whether you want your own lawyer or whether you want to join some group of others for lawyers. All I can tell you is that I consider it my job to protect, especially you net losers. And I'm going to do that job as well as I can. And so whether you need a lawyer to do something else, that's really up to you. But to the extent that what you're looking for is to get as much money back as you can possibly get back, that's my job. And if you think you want somebody else to help you with that, you do what you think is in your best interest. individual taxes. I hate to dodge anything, but I'm going to dodge this one completely for two reasons. One, the last thing I can do is give you individual tax advice, and two, if I did, it would be incompetent. I'm not a tax lawyer, and I couldn't give you advice if I had any. So to the extent that there are tax issues, you need to just take that up with the people who do your taxes or your tax attorneys or whoever you work with. But you're just going to have to go somewhere else for that answer. I also had questions about how were people who were doing services for Rex Venture, just independent contractors such as that, where do they stand in getting paid? Well, for any services that were rendered before the receivership came in, August 17th, they're just going to have to get in line with everyone else. They're just another group of people who are owed money by Rex Venture Group. And so we'll have on the claim form a place for people like that who rendered a service, have a bill outstanding that hasn't been paid. They're going to get in line and get treated like everyone else who is out money because of this operation. A large percentage of emails that I get from day one and up through probably while we've been on this call is to argue to me that this was not a Ponzi scheme, that everything would have been better if left well enough alone, that the SEC and I guess me have ruined their lives. And I just want to come back to what I said before, that hopefully I didn't ruin your life, that this thing was decided before I got in, that the SEC alleged and Paul Burks agreed to surrender the company, the court took assets of it, and then I came in. But as I told you at the beginning, in my experience, there isn't any doubt that this is a Ponzi scheme, and eventually I'm going to have to prove it. We'll go into court with somebody that we think owes the rest of you money and sue them to get that money back. And when we sue them, we'll have to allege and we'll have to prove that this was a Ponzi scheme, and that will do. So, feel free to continue to send me emails telling me it's not a Ponzi scheme and that I'm in the wrong, but I'm not going to be persuaded by it. But you send them if you want. I want to talk about a couple other things that are pending right now. And I've gotten a lot of emails about this. A couple of weeks ago or so, a particular attorney filed a motion to be appointed what he called the examiner in this receivership. And what that essentially means is somebody to look over my shoulder and make sure that I'm doing things the way that examiner thinks they ought to be done. And today we will file, if we haven't already, a response to that motion. I really find that motion absurd, I have to be honest with you. The lawyer who is asked to be appointed as the examiner is already representing several hundred net winners. Yet in the motion they asked to be appointed as examiner to be the voice of the affiliates. Now, 9 out of 10 affiliates have an interest contrary to those net winners. So I don't think such an examiner is the right person to be supposedly speaking as the voice for all 900,000 of you. Separate and apart from that, my job is to speak for you. And I've got plenty of bosses, not just the tens of thousands of you who send me emails, but I've got a U.S. District Court judge watching me, and I have to answer to the SEC as well. And I take my job very seriously. So I think an examiner to come in and look over my shoulder, when I already got people looking over my shoulder, and to get paid out of the funds that we're trying to recover so we can give them to you, is, as I said before, absurd. And we'll be filing our response today, if we haven't already, as I said, opposing that motion, and I hope the court doesn't grant it. As recently as Friday, somebody else, a big net winner, filed a motion with the court asking that the receivership be dissolved in its entirety, that the SEC should have never brought the case, the court should have never ordered the company into receivership, and that I should have never been appointed, and to try to unwind all this. We've got a couple of weeks to respond to that one, but if you are aware of it, you folks are pretty well organized and seem to get information usually more quickly than I do, we're going to be opposing that as well. The receivership's here to stay, I think, and I hope, and it should be, because we had originally been required to file what's called the final liquidation plan with the court. We today asked the court to extend that plan to the end of January, and I hope you can start getting a sense for why we did that. Trying to get our arms around the financial information of this company and understand it, and to go through the terabytes of data and the 900 million transactions, we're just not ready to put a final liquidation plan together the way it's supposed to look. Because in a final liquidation plan, it should include things in there like the claim form, what claims are going to be honored, what claims will not be honored, what's the kind of proof that's necessary to establish a claim, what's our projection about how much money we're going to be able to recover at the end of the day. Not just what we have in hand now, but what we'll be able to get through either trying to chase money into other financial institutions that we're not now aware of, or, as I said before, trying to get money back from people who took out more than they put in. We need to be able to project at least a plan and have some idea that we can put in front of the court, in front of you folks, what it's going to look like at the end of the day. And frankly, we just weren't ready to do that today. We will be by the end of January. And another question that I wanted to address, I think I brought this up more often than the emails I get. But folks have said, look, you're sitting on a lot of money. Why can't you at least send some of it back? And I'm all for it, and I want to do that. To start sending any money back, we do have to have a court-approved claims process. And we are going to have to evaluate claims. I'm going to have to leave that claim period open long enough to give people a chance to do it. But what I intend to ask the court to do is, when we have the claims forms submitted and we've been able to evaluate them, I do intend to ask the court to do a preliminary distribution on whatever basis we're able to make at that point. Because I don't see any reason to sit on $300 million and wait till the end of the day when we get in everything we're going to get and then make a distribution. Now, the one caution I would have about that, I want to make sure even that's cost effective. I don't know how many claims there are going to be, and that has a lot to do with how much it will cost to make a payment. But I'm guessing that the cost of making an interim payment will be worth getting money out there before the last dollar is recovered, because I don't know how long that's going to take. So it is my hope and my intention to go to the court when the claims process has been evaluated and to ask the court for permission to make a significant distribution based on the claims that we've received and approved. Now that, again, that's going to be several months out. As we do the timeline, we'll have a proposed claim form to the court at the end of January. The court will take some time to have interested parties weigh in on that proposed claim form, make sure that it's right, that the court's satisfied with it. Then it'll be posted on our website, and we'll have to allow some period of time, as I said, maybe a couple of months, for people to see it, get their records together, and get things into us. And then we're going to need some time to evaluate it. You know, we're not necessarily going to take everybody at their word when they say, you know, the receivership owes them $10,000, for instance. We're going to check the records of Zeek. We're going to double check that with the financial institutions. We're going to check that against the e-wallets and make sure that we are really confident that when someone says they're owed $5,000, that they really are owed $5,000. And that will take some period of time. Not long, I hope, but it's going to take some time depending on how many claims there are. But when that's done, we will go to the court and ask permission to start making payments to people. And then, as we spin things out even longer during this receivership and start, unfortunately, having to sue people to get money back for you folks, when we're all said and done, then we'll make a final distribution. But I want to get some money into your hands as quickly as I can. And a friend of mine once said, that's the end of my prepared remarks. If we have questions that folks have been sending in, I intentionally wanted to leave enough time to take your questions. Because I really prefer the question and answer to the lecture. I'll lecture if you make me, but it's not really my preference. It says, will we get access to our back offices? We need that information for claims. I'm really sensitive to that, and I understand that. And we're going to have to figure out how to do that because I know a lot of you have limited records or sometimes even no records based on your emails. I'm here to tell expensive, and I won't go into all of it, but at one time, when that website was up and one of the busiest in the world, frankly, the data vendor for that was rightly charging a whole lot of money. And to duplicate that would cost us, meaning you, a whole lot of money. So one thing we are looking at is trying to figure out how, on a selected basis and as needed, to give folks access to their back office so that you can find the records and either agree with what we've said is your loss or your gain, or to fight with us about it. We're going to do that. I'm not sure how yet because it's technically difficult and it is expensive. But that's a wholly legitimate question and something we know we're going to have to work with. Another question here. What about retail customers who bought bids that haven't been used? Well, that's an interesting question because they haven't been used and they never will be, obviously. This thing has been shut down and never come back to life. And that is one of the questions that we're trying to figure out. All right, what do we do with people like that? Is that a compensable expense? I'm not sure the answer. We'll have it figured out in January and we'll go to the court with it. But that's one of, 6, 8, 10 things that we're having to decide. What are we going to do about that? Are we going to compensate people for that? Another question. I'll just read them and hope they're good ones. If a person used most of the money he received from Zeek to give to friends for them to purchase bids in Zeek, can that amount be subtracted from the money that is clawed back? Well, now you're starting to get a sense of the complicated math that we're dealing with here. Who is really out of money and who has really made money? So to be more generic than maybe this question is generally, hopefully not overly lawyerly about it. It depends. We understand that some people paid money to others that went into Zeek, and we understand that people took money out of Zeek that went to others. And so we're going to try to account for that in the claim form, and then we're going to try to follow the money enough so that we have confidence that we understand where the money came from and where it went. Because I said the goal is take from people or to recover from people more money that they took out than they put in, and to put money back to people who put in more money than they gave out. So all the permutations that you can think of that come from that, that's the goal. And we'll try to, every one of these scenarios, and I've gotten many dozens very creatively, of how the money flowed and who it went, who made payments and who got payments. We're going to try to address that in the claims form and then as we evaluate claims. So you're right, that's one of the things we're looking at. What records do we need to gather for the claims process? I only have a copy of a cashier's check. That may be enough. Again, it's going to depend to a certain extent. More is better because when we get your claim form saying, look, I put in this amount of money and I never took any out, or I took out less than I put in, or whatever it is, the more documentation you have that substantiates that, the easier it is for us to make a judgment that that's a legitimate claim, and the quicker it is for us to make a judgment. I mean, even if somebody just sent in a claim form saying, I have no records, but I put $5,000 into this thing and never took anything out. Well, we're going to do our best to find out if that's true. We'll go into the company's databases. We'll go into e-wallets to the extent we have those records. We'll go into bank records. We will try to help you establish your claim. But it'll be a lot easier and a lot faster and a lot less expensive if you can give us records. Some of you folks keep incredible records. In fact, I guess I should mention this. We're trying to figure out the errors and the flaws in the company's records. A lot of affiliates have sent us very detailed records and accounts of the money they put in and the money they took out and from where. And we've been able to take those records and go into the company's databases and figure out what's right in there, what's wrong in there, and why. And so, send us your records. It really is helpful. But especially in the claims process, I guess the bottom line answer is, whatever you got, give it to us. And if you don't have it, we'll try to help you establish the claim any way we can. Because this isn't about record keeping, it's about making people as whole as possible. What will be the process for returning money? Okay, we've tried to cover this before, but I know this is of utmost interest to everyone. And then follow-up question, who gets paid first, and does citizenship matter? Well, the process for returning money, I'm not exactly sure beyond the claims process that I've described already. Maybe what this question is getting at, as I saw one this afternoon, was will this be done by check, electronic wire transfer, are we going to use the e-wallets? That's another question that I'm not ready to answer yet, because there are only two things that matter to me about that, is getting the money back out to people and doing it in a cost-effective way. So if the combination of that is using an e-wallet, that's what we're going to do. If those two factors weigh into cutting checks, that's what we're going to do. So I don't have an answer for you on that yet. But it's going to be cost-effective, and it's going to be done in a way that I know that if you should get money back, and I have it to give it to you if you're going to get it. The other question was, who gets paid first? I think everybody's going to get paid at the same time, frankly. Again, it's up to the court to approve whatever it is I recommend. But my view right now is that we're going to do this on a percentage basis, that if there's $600 million lost and $400 million recovered, everybody's going to get two-thirds of what they lost. That's my judgment right now. I may change it, but I don't think so. And everybody's going to get it at the same time. We're not going to pay some people before others. When it happens, and it happens for all. And then the other question was, does citizenship matter? No, not to me. And I don't think it could or should. If people lost money and they just didn't happen to live in the U.S., everybody was in this together. And everybody's going to come out of this together as whole as we're able to make them. So I'm not going to pay any attention to citizenship. Yes, two other questions. I've gotten a lot of emails, really from early on, and still up until today, that a lot of people saying they've already gotten money back. Not from me, they haven't. I don't know what they're talking about, whether they've gotten money from somewhere, or they're just not shooting square with you. But nobody has gotten any money back from the receivership, and they won't until the claims process has been approved and evaluated. And that's the first time and only time anybody's going to get money back from the receivership. Now, we've paid some bills. We paid the water bill. We paid the lease bill, things like that. But nobody who was involved in Zeek Rewards, either as a net winner or net loser, has gotten any money back from the receivership. The no victim speaks to me personally. I'm not sure what that is. Oh, well, that's not entirely true. I'm sorry. Yeah, I know that I don't speak to very many of you, and I don't know how to describe this in a way that will really convey it. In those first few days and weeks, I literally received tens of thousands of emails. My voicemail was so full, no one could leave a message. And we were working around the clock on the things that we needed to do to lock down money and set things up so we can get it back to you. So, especially early on, there frankly just wasn't enough time to talk to any of you, much less all of you. Now, I have talked to several of you, but I guess in the grand scheme of things, it doesn't seem like many. And again, I hope you can understand this. I have to be selective about that. I mean, there are 900,000 of you out there. If I started taking everyone's calls, I wouldn't do anything else. We wouldn't have a claims process. We wouldn't be recovering assets. We wouldn't be figuring out how to get money back to you. I do respond to some emails. Not when you send it to my work address, but when you send them to the receivership, and I get the summary every day, and I get some specific emails from folks that address particular things, I have now gotten freed up enough that I'm responding to some of those. I don't want you to have hurt feelings if I don't respond to yours. Some of them are alerting me to one thing or another, and then I'm following up with it. Mostly what we do with your emails, because there are tens of thousands of them, we pull them into sort of categories of things we need to be aware of or that we need to address to you and keep you informed about. And then we put something up on the website that addresses or answers a question that we hope will have application to many of you. Because frankly, I can't talk to all of you. As I said, I wish we could have a town hall meeting every week and just get together for an hour every week and talk about what happened this week. With 900,000 people in 100 countries, that's not going to happen. And so I will try to be better in responding to you, or at least making you feel like I'm giving you the attention you deserve, because I'm not trying to slight you. I'm just trying to make sure I do during the day the things that would be best for you, and frankly, that might not necessarily be answering your individual email or phone call. I apologize if that hurts your feelings, but there's only 24 hours. What's going to happen to Rex's personal and real property? We are going to sell it. We've already started the process of engaging an appraiser, and for certain real property, we have to get court permission to do it. But the assets of the company, I was tasked with seizing and liquidating the assets of the company. And that includes office furniture. It includes real estate. It includes everything we could lay our hands on. And so that'll be in our final liquidation plan as well. These are the assets that we've been able to define and put our hands on. This is what we think they're worth. This is how we propose to sell them, whether it's just an auction or a person-to-person sale after listing property or whatever it is. Whatever's going to have the best chance of recovering the most money, that's what we're going to do with the property. We get close to the end because I've gone through the list you've given me. Well, we got 5 minutes. Do we have any more questions? Find some hard ones because I don't want to ask for the website again, okay? It's zeek rewards receivership, all one word, .com.
It says receive money in preliminary distribution, and then we receive more money and get more money later. Like, will there be more than one opportunity for them to get funds if there's a preliminary distribution?
Yeah, maybe I wasn't clear about that. I guess the way this question, maybe you couldn't hear it, was, how does this work if you do a preliminary or an interim distribution and then a final one? My guess is that the way this will work is after we have an approved claims process and the form, and we've evaluated and we've decided 400,000 people are entitled to this much money, whatever it is, and we have to divvy things up by a percentage. We will set aside this big chunk of money that we're sitting on now, and on that percentage basis, we'll send it out to everybody. And then as more money comes in, as I hope it will and believes it will over the course of this thing by trying to get money back from the net winners, we'll fill that pool again. Probably not as big as it is now, but we'll fill that pool. And when that pool is as full as it's going to get, then we'll make a final distribution on the same basis, the same percentage paid out to everybody that's been determined entitled to recovery. It'll work that way. How big is the McGuire Woods team at this? Working. There are right now probably 8 or 10 of us that I would call the core team, doing various functions, everything from the litigation piece of it. We're having to fight with a lot of lawyers right now. We're dealing with things that matter to lawyers more than to you. We're arguing over issues of attorney-client privilege with some stuff. We're bending on, for lack of a better word. Some class actions that have been brought around the country that, in my view, are run the risk of just frustrating our efforts and costing you, the affiliates, money. So there are about 8 or 10 of us that spend most of our day, including me, on this. Now, early on, there were a whole lot of people on it. Now, we don't have time anymore, and you wouldn't care anyway, I guess, but just how hectic and crazy it was in those first few weeks. So there were a lot of people working on it early on. Not so many now, as I said, and I hope you believe me, because I really want you to. We're trying to make this as lean and as cost-effective as possible. And so we have as few people as possible working on it, and of those people, I want them to really know this case and know this issue so that they don't spend time learning it again. We're being told, well, look, we need you to do this, but it's going to take a few hours for you to understand why and how to do it. So as I said, right now, it's probably 8 or 10 of us that are devoted to this. We have a big team at FTI, which is our financial analyst, dealing with the data, because I wouldn't be confident to do that, and most of the people in my office That doesn't have anything to do with me anymore. There was one question I saw earlier today about, well, why did he only have to pay a $4 million fine? The premise of that question isn't right. He did pay a $4 million fine, and the original complaint and the order that he agreed to a $4 million fine to be paid to the SEC. I didn't agree to anything. If he has, and I suppose you suspect he does, more money from Zeek than he put in, then in my mind he's a net winner, and he owes the receivership money. So just because he's paid the SEC $4 million doesn't mean he's done paying people, as far as I'm concerned. There's been asked the question several times whether the interest whether the money we have now is earning interest, and that's a difficult question, and one that I wrestled with even today for a while. Right now, it's not. We were advised by the court that we ought not have it in an interest-bearing account for some very technical legal reasons. One of them, which maybe seem remote, $300 million is only insurable by the FDIC up to $100,000. Now, not that we think our bank's going to go underwater, although, as we all remember, banks almost did. But we have to be really careful about not risking what we've got. Now, and there are some other tax-related issues to that about how it affects the receivership and whether it's really, is it a money maker or a money loser for us. But as I said, I re-examined that question today, whether we should put that in an interest-bearing account, weighing the risk again to how it benefits or detracts from receivership. But it's a great question and one I looked at today. And I'm being given the high sign that we're out of time that says last thing to read. Please read this. All right. If some of you missed any of this call, or if the audio may have cut out, we're running this and we'll turn it around as we're recording this, and we'll turn it around as quickly as we can. The website, again, zeekrewardsreceivership.com. And again, I hope that you folks will continue to email both the receivership, and then for some little while here, we're going to leave the mailbox open at the McGuire Woods that we had attached to the announcement for this, because I want your feedback on this. I want to know whether I answered the questions that you wanted answered. If I didn't, well, maybe we'll need to do this again.